So I guess we can get started here.
Yes.
All right. Well, thank you everyone for joining us today on our roundtable for the Paycheck Protection Program. We're here to give you the latest information and provide industry insights, as this is a moving vehicle at this time, but we're happy to share the information that we have. My name is Elise Rosemarin. I'm a vice president here at ACAM. Joining me this evening is Adam Finkelstein. He's a partner at Kagan, Lubick, Lepper, Finkelstein, and Gold. Say that 10 times. I did it though. He's been a partner since 2004. He oversees much of the firm's cooperative and condominium servicing and real estate departments. He is regularly involved as a general counsel, advising his clients and dealing with their general governance issues, as well as the drafting and negotiation of a wide array of contracts, leases, and mortgage loan documents. Thanks, Adam, for joining us. We have Neil Sonenberg. Neil is a CPA and co-partner in charge of the real estate group Marks Paneth. With almost over 40 years of public accounting, Mr. Sonenberg excels in a wide range of tax and accounting disciplines. His out-of-the-box thinking and passion provides clients with an array of planning opportunities to maximize both tax savings and profits. Thank you, Neil.
Thank you.
Then from ACAM, we've got Ajo Kurian, who's a senior vice president here at ACAM. Ajo has a working knowledge of every facet of the residential building management world. His understanding of the needs of property owners and residents has been critical to ACAM clients throughout the COVID-19 pandemic, helping ACAM manage its properties, interpret guidelines, and incorporate them into the building's day-to-day and long-term operations and procedures. Thank you, Ajo. And last but definitely not least, we have David Palmer also joining us here from ACAM. He is also a vice president of finance. He is a certified public accountant, certified managerial accountant, and is certified in financial management. He is certified in a lot more than I am, I'll tell you that. He has been a financial executive in the property management industry for over 9 years. He holds a New York State property and casualty insurance license and has been responsible for bringing innovative ideas to the property management industry. Thank you, gentlemen, for joining us. So today what we're going to be doing is doing an overview of the Ppp process. We're going to share highlights of the program, and then we're going to provide you some timelines to consider. We're also going to be doing a Q&A, since I'm sure many of you will have questions. Please feel free to provide your questions in our Q&A box, and we will be getting to them at the end. We will, of course, answer any questions that come in. You are our clients, and you're very important to us. If there are anything that we do not discuss here and you forget, or you decide you have another question after tonight, please email us at marketing@acam.com. And at the end of today, there will also be a slide which will also share all of our information. So feel free to reach out to us at any time. All right, thank you, gentlemen. And I'm going to kick it off to Adam, who'll go do our overview.
Sure. Just for historical perspective, back in March of last year, really at the very beginnings of the pandemic and where we didn't really know where this story would play out, Congress passed the Coronavirus Aid, Relief, and Economic Security Act, the CARES Act. And that effectively put into the system $349 billion of loans for small businesses. Now, when that first was passed, and for several days thereafter, the belief was that this program was going to be made available to co-ops and potentially condominiums. And a lot of analysis was done at that time. Well, in the about the week or so after that was adopted, the SBA came out with their regulations, which made it clear that applying their rules, the program would not be extended to those type of entities. So a lot of buildings who, standing at the beginning of this unknown, kind of had the rug pulled out from under them. My office had engaged in a lot of back and forth discussion with representatives through the SBA, trying to get them to understand the needs of the buildings that we represented. And, you know, I don't know if at the end of the day that resulted in the inclusion now going forward, because on December 27th, Congress passed the Omnibus Appropriations and Coronavirus Relief Package. And that was basically PPP2. And in that, it was very clear, made very clear that co-ops could enjoy the benefits of applying if they satisfied the other criteria for the program. Condominiums, as we sit right now, appear to be, for the most part, out in the cold, unable to apply. So that's the backdrop. And basically now there's $284 billion in funding available for PPP2, which is going to involve buildings and entities that had not applied the first time around, and those entities that qualify for a second wave of funding. And since co-ops were unable to apply then, I doubt any people are going to be looking at the second wave criteria, but I guess we could touch upon them briefly a little bit later on. So that's basically the overview of where we are. We currently have $284 billion of taxpayer money waiting to be dispersed through the SBA for qualified entities, including co-ops.
Thank you. All right, so now can we get to maybe some of the other application requirements and questions that might be addressed during this process?
Well, you want me to
Sure,
take
please,
us
Tom.
through the
Happy.
application? So with this $284 billion, which is quite a large number. First, before I start, actually, I should thank ACAM for providing this forum for their co-op housing entities, and we appreciate them inviting Adam and myself to try to enlighten this pretty complex kind of environment regarding the PPP program, or PPP2, however you like to define it. So much of what Adam said, it was just recently passed, and they've come out with a interesting application. Take it through. It's not too dissimilar to the last time, but they have added many other features to help embellish and really try to give individual entities some more room so that the government can indeed fund PPP. If one recalls, the last go around, there was actually PPP money left. And so the government tried, based on this program, to try to loosen some strings. And one of the key things on the newest application that was revised as of January 8th, 2021, is they actually have a box, and some agencies we've seen, and we do about 150 of these co-ops at Marks Paneth, have made a mistake. I mean, they immediately check a C corporation box, and they really do not check that it is a housing cooperative. That's very important to make certain on the application that you do provide. And it's really one of the first boxes. They want you to check one and not to check C corporation. Make sure you check the housing cooperative box. And then it takes you through a series of a variety of other questions where, of course, one puts the address, the basic information that one can find in the tax return. And then some of the other key components of it are if you have a sponsor in the building that owns 20% or more of the cooperative units, there is more special type of narrative that you really have to break down. You have to add in a separate sheet the items that define the sponsor, what exactly he owns, and that unfortunately can slow down the process from what we have had within discussions with variety of people supposedly in the know. And then the application continues with a list of questions that they ask the applicant. And don't forget, this is a group shareholding type of an adventure where the board is doing this as a whole. But they ask such questions if there were criminal activities, if one had different kinds of a felony, you'd be kicked out. But basically, for most of our co-op housing entities, these things will not apply. The application doesn't seem to be over cumbersome. One of the key questions that are being asked is, when is the bank going to allow these applications to come, and what exactly is the process? And just to highlight that, it's really kind of like the same way as the first one. When the bank gives the green light to put through these applications, we have to be at the ready. We have to be at the ready, which means that these really have to be all filled out and ready to go, because it's going to be on a first come, first served basis. It was frankly supposed to get really started this past Wednesday, was the early indication, but with the government being a little bit in disarray, to say the least, has been postponed. And the earliest guesstimate would be sometime after Martin Luther King's holiday coming up on Monday. So perhaps it'll be next Tuesday or Wednesday. And there is discussion as to how many banks can you apply for. ACAM has a very nice, solid connection with their banking entity. And the plan is right now to put it through that banking entity. And just like we had a little bit of a mock kind of go through earlier in the day, and Adam actually put through the fact that just like in the restaurant, you don't try to go to the general restaurant in a fine restaurant in the old days, not now. Now the restaurants are dying, but in the old days, you'd have to call up and know somebody to get somewhere. Just like the bank, if you know somebody at the bank and ACAM has a very good relationship, hopefully that'll end up to allow this to go through quickly and get to the SBA for the processing portion. But by the same token, you could go through several banks just to hedge your bet and send out the application. You're not precluded from just using one bank. So that would be a recommendation to try to perhaps spread our wings and entertain several kinds of lenders. And an overview, I don't know whether we should go through specifics right now or we're going to come back to that. I don't.
Sure, you can feel free to touch upon. Yeah.
I think one thing to just touch upon, because I think it's probably the critical question now that we know that co-ops can even apply, and a lot of the discussion I've been having, over the last week or so, is do we qualify? And this is really a question only the board can answer in many cases, because one of the requirements is an affirmation that as a result of COVID, economic uncertainty brought on by COVID is making the ability to operate, putting it into question. And, I've been going through an analysis with the boards that have come to me so far. And we look at things to try and figure out, can we legitimately make that statement? We look at what's the reserves. If a building has a few $1 million in reserves, it's going to be more difficult to make that argument if they have not had a significant increase in shareholder default, shareholders in the building unable to pay their regular maintenance. And really buildings that have commercial revenues, that's where they probably are going to see more of a likelihood of making the argument, again, depending on the numbers. One building in particular had a few $100,000 that they had to write off, but amongst the size of the building and the demographic of the building, the board president and treasurer both came to the conclusion that this is not going to be a challenge for our shareholders, so we don't really have economic uncertainty. When we were first talking about it in March, when we thought the co-ops would apply, nobody really knew what COVID was going to do. Where are we going to wind up with this? So I think the subjective element to that question was a little bit easier to answer then, because you really didn't know. But we now have, a good 9-month track record, and hopefully we are on the verge of the end of this. So we see, hopefully, with the vaccinations rolling out, in a light at the end of the tunnel. I think there's a little less subjectivity that goes into it, and boards need to be able to make, I believe, a fairly good faith argument that they believe that they need these monies to continue operations. And again, that's a building by building, circumstance by circumstance question. But at the end of the day, those board members are signing an application. It's being submitted to the federal government to get these funds. And I'm conservative. I don't want to have a volunteer board member put their neck on the line unless it's justifiable.
So just, and this is a point of debate, and this is where boards need, I would think, a high quality managing agent, a high quality like ACAM, a high quality lawyer like Adam, and a high quality accounting firm like Marks Paneth, because it is very individualistic, and it has to really be doled into and the I's dotted and the T's crossed. Because there's various arguments that could be made because this amount of economic stability is really an art, not a science, in all due respect. And one has to consider a balance sheet as well as a revenue and expense financial statement. Those are critical, both the certified audited one from the prior year and along with budgets for the new year. Those things are really vital because, as Adam definitely pointed out, if you have a large receivable collection, that doesn't bode well. However, if you have to raise maintenance a higher amount of money, and you do not have constant, like in the old days, we had a lot of transfer fees, we had a lot of resales. Right now, unfortunately, co-ops can't get arrested for resales. I mean, resales have slowed a great deal, putting a strain and stress on the economic, financial, day-to-day activities of a co-op. And that would absolutely enter into a consideration of whether one signs these forms of economic hardship or not, along with, may I add, the local law 11 work and other, whether you call them capital improvements or large renovations or large expenses to a co-op. If you have major elevator repairs, major plumbing repairs, or frankly, major heating, ventilation, and air conditioning repairs to protect the plant, to protect people's jobs, frankly, to even help outside consulting jobs. These are all the things that are in the perspective, frankly, of the PPP. So by rounding out an argument, and this goes to the viability because you could end up then specially assessing your shareholders some larger amount of monies, along with larger, as I said earlier, maintenance increases. And this is something, therefore, that a viable argument can be made. And I only do things from a perspective that I would feel comfortable recommending. I'm on several boards myself, and I understand the fiduciary responsibility. That's why this, as Adam said, this has to be weighed gravely. Can't just be with a wink and a smile and you sign those forms, because they do carry, if they're completely fallacious, you could get into fraud types of statutes. However, by making these arguments that I frankly laid out and documenting these in the all-important board of director minutes, those are very important to document these types of thoughts. I think you absolutely, at worst case scenario, these types of loans, which they do come in as loans. They are not forgiven from day one, even though the government says when they are forgiven, it's going to be tax-free, which was a wonderful type of thing, which was the original intention. But the point is that they come in as loans. So the worst case, and it's a cheap loan, it's a half of 1%. You're not going to get money cheaper even nowadays. So worst case scenario, you will have to punt the forgiveness portion or the grant portion, and you'll have to pay back the loan with a very low interest rate. So again, can't be fallacious. All these factors have to be weighed, and that's why you deal with a triangle: good accounting firm, a good law firm, and a good managing agent put together to help advise a board.
I didn't mean to limit the analysis to those 3 points. It's the holistic budget, how it's looking in light of and Neil's point about revenues from other sources. One thing to bear in mind, because in my discussions there has been some confusion, because the second wave PPP, companies that did take first line money, there is a 25% test that has to be applied. That does not apply if we're a first-time applicant. So you don't need to demonstrate 25% reduction in your economics. That's only for second-time applicants.
Very helpful.
There was a lot of confusion on that point. So, and at first, when it first came out, the way, as usual, the way the federal government or the SBA writes these laws, it was 5,600 pages. It's the longest bunch of laws that have come out of legislation. And originally it was contemplated that perhaps the co-ops would have to have a 25% haircut. But as Adam has pointed out, rightfully so, it is absolutely not the case. It's just like the first go around with expansion. Should we get it all into the expansion parts? I'm not sure.
Yeah.
Yes?
Yeah.
Yes, you said?
Thank you.
So just so everyone should know on the particulars, the co-ops per se, there's a little bit of choice here. There's several choices. It's like, it's a football team. You have to figure out how to get to the end zone. So, and you have to make the best dance. So first you have to evaluate 60% of this overall package, 60 of this overall package has to be payroll, Otherwise you fail and you don't get PPP. You don't pass go.
You don't get forgiveness.
Right. You don't get forgiveness. Well, basically, right. You would get the loan. Thank you. You don't get the forgiveness. So you don't pass go. You don't collect the 200. So it's very vital that the 60% is there. So and how do you determine that 60%? So you could evaluate the 2019 payroll for the year, divided by 12. This is the simplistic, divided by 12, and you multiply by 2.5 times factor. But first you evaluate the 2019 payroll versus the 2020 payroll. Now, in many cases, one would think because the economy has been hurting, that the 2019 payroll would be the higher of the two choices. However, the co-ops being in the industry that they are and having the union shops that they do, I would wager to say, and working with several of our clients already on this, that the 2020 group of wages, frankly, is higher than the 2019. So as a choice, we have been selecting the 2020 book of wages, and the 941s. As I'm speaking, I'm getting some emails about the 941s. Truth is, you will not have to furnish the actual full 941s with the application right away. So if you are using 2020, by January 31st, those 941s have to be done for the fourth quarter. So you'll be able to use on a practical basis the 2020 if it does yield you the higher amount, which it should be. So on the form, you would end up placing that information on the form. And as I said, you multiply by 12, and multiply by 2.5. But they added some additional amounts which will be allowed to help embellish even further the amount of PPP. By the way, just as an aside, if you have people that are making over all the old rules apply. So if you had somebody that made more than $100,000 in wages annually, you're stopped at that $100,000 amount. You cannot get more than up to $100,000 for any individual. But there are accoutrements, as I said, that are added to this pie that the government allows you to have. And on the last go around, it lets you have rent. Some co-ops are renting out space. We have some of those, but they allow you to add rent. They allow you to add health insurance. All co-ops, if they're under the union shop, are paying the health and welfare. They allow you to add pension. There was a question to us whether you're allowed to add dues. We are coming on the side that you're not allowed to add dues. Those are some of the basic tenets. And then the added amounts they allowed were such things as PPE, the special protection type of equipment. So if a co-op put up these new plastics, which became a real cottage industry, you'd be entitled to add that, frankly, to the pie outside the 60%. And they even allowing you to put certain computer software equipments for betterments to the entity. They allow that. So they've really broadened the base. Just to touch upon a few, this phone never stops ringing, and I apologize. Just to touch upon a few types of things that they are allowing you to allow. They even went so far to allow for precautions against looting. We know, unfortunately, what happened earlier in the summertime during this COVID plagued New York City, where we had riots. Unfortunately, the government's allowing, if you made special costs to reinforce the building or have protection, you could take those as far as the embellishments as well. So they have sweetened the pot, so to speak, to try to allow more money flow. Of course, let's overall look, because they want to help the economy and they want to help people. It's the multiplier effect. They want to keep people working. And as I said, they want to keep the economy viable. So that's the basics behind it. And again, the boards need the professionals to help them evaluate the best way to format this. And again, as quickly as possible, because it is unfortunately, that's the only unfortunate thing. It is a first come, first serve basis. I mean, it's not to say that Biden and the new administration, if the money goes fast, may do a second helping like they did the last time. I think that would be in the cards, frankly, with Biden, but I'm not the best fortune teller. Just look at my stock picks. But it's something that one should not automatically say, "Oh, we blew it." But you should be quick to the table so we don't fall into a possible second shot if it even comes to fruition.
Very helpful. Thank you, Neil.
Pleasure.
Yeah, I appreciate it. So we're here to obviously support our clients, and this is to also help ACAM's clients understand the preparation, support, and resolutions that we will provide for you. So I'm going to turn this over to Ajo, who will speak on behalf of ACAM. And just a quick question, Ajo, are we charging an application processing fee for this?
Oh, absolutely not. ACAM recognizes that our buildings and our clients have experienced a number of additional expenses since COVID. So we're not going to be charging an application fee or processing.
Good to know.
So we recognize and value the critical importance of the Ppp program for our clients. So to that end, since the program was signed into law, we have worked tirelessly to gather information and coordinate our internal resources to fulfill our number one priority, which is to ensure the streamlined and efficient application process for our clients. When we received the SBA application, which was last weekend, we proactively completed the paper applications on behalf of our clients and sent them to our clients for our review. So all of our clients have paper applications, which we filled out. They provide the loan amount that's to be provided for. And this is so that the clients can review, the co-op clients can review the applications with their respective attorneys and CPAs. We've also gathered all the backup data and documents that may be needed during the next step, which is the submission of the application via the bank's application portal. In addition to this, we've formed a team of internal resources who are standing by to input the applications once the portals are opened up. We have two primary concerns at this point, which are largely out of our control. One is any additional information that a lender may specifically request that's outside of the SBA's requirements that we know of right now. And then two is the timing, as Neil and Adam mentioned, the timing of the lenders in opening up their application portals. In order to mitigate this and just to keep in touch with what information is coming out, we will remain in constant communication with industry professionals and other resources to continue providing our clients with information as we receive it. I'm going to turn it over to David Palmer, our in-house CPA, to provide additional information on our communication and follow-up with the lenders.
Thank you, Ajo. Yeah, we've been actually incredibly aggressive with various lending institutions regarding this program. One of the things that was mentioned earlier by Mark is that the situation is incredibly fluid. It's not only an issue with the banks, it's the issue with their internal underwriters dealing with the SBA, the legal teams, the banks dealing with their IT resources to get the portals up and running. But let me just sort of give you the context in which we approach our strategy and sort of to make sure that our clients are some of the first in line for these loans. When the program was first announced that cooperatives were able to participate, the first strategy was let's go with the institutions that we know, people where we have our operating accounts or we have reserve accounts or underlying mortgages. Then as more information about the program became available and they announced that certain institutions like community banks or minority depository institutions would be first in line, we then set on a path to make introductions with those type of institutions so that we could again be first online. Through the communication with a lot of these institutions, and as we're mentioning, because there's all these things in which no one seems to be ready, we decided to go back to a strategy of let's go with the institution we know, because the reality of the loan is that it isn't the first people to enter data into our portal, because the second stage of that is the bank underwriting process before it gets to the SBA. And the issue with underwriting is if you already have a current relationship with the bank, you squeeze that timeline in underwriting. So the fact that one institution may open up a day earlier might be good as step one, but step two, if you do not have an existing relationship and now they're requesting documents that they don't have, but your current bank does, you can squeeze that second part and get that document to the SBA for their approval. We're in daily communication with all of these institutions. We don't let them go, but that's sort of our strategy and overall approach to this.
Great, very helpful. So I think right now we're going to open it up to our Q&A portion. I know several people have already written in some questions, so I'm going to start. And at this point, if anyone has any questions, please put your questions into our Q&A box. And once again, if we don't get to them by the end of this, we are happy to get back to you very shortly after. All right, so the first question we have is, when do you think the non-community lenders, for example, a big bank, will open their portals to accept applications? I guess this question we can have Neil.
So I kind of covered that in my remarks, but
okay.
Because I'm happy to repeat it. So unfortunately, we thought it may have been opening up this past week, but that's not coming to fruition because of what's going on in Washington. We believe we do see by talking to these banks, and no one really knows because this is so new, that they are anticipating an opening sometime next week after the Martin Luther King Day holiday. But the truth is, nobody really knows. Last time this happened, there were certain money centers opened up and certain money centers didn't for whatever reason. So that may happen again. It may be such an overflow that there's a crash. That may very well happen because software is only as good as software is, and hardware is only as good as hardware is. So the point is, however, as I mentioned when I spoke before, that you got to be at the ready. So, through ACAM and through your accountant and lawyer, you should have it all ready, set, and go if you're committed to doing this, and just be ready to enter into the various banking systems once they do open up. Can't be more definitive than that. Unfortunately, I do not have a crystal ball.
I think that's just what Neil had mentioned before, and I believe in it as well. That's where your relationship with your institutions comes in handy. If you're constantly badgering your contact person at whatever institution you're planning on applying to, and making them aware that you want this handled promptly, I think you probably, depending on the strength of that relationship, may be able to get the heads up as soon as it's going live, and have that happen. Again, every institution is different, every relationship is different, but I do know instances where the squeaky wheel definitely got the grease. So work your relationships.
That's good advice. Okay, so does every board member need to qualify under the certifications portions, or only the board members who's executing the application and any principals?
I actually had some clients apply, and we took the position that the officers would need to make the certifications, and we required each officer to fill it out. And thankfully, there were no issues of any officers who didn't meet all of the qualifications. And we basically kept that in the file so that the ultimate signatory who's confirming these all to be true can then say, if ever asked, he could say, look, here's their certification. The question is, what happens if one of the officers had an issue where they couldn't answer in a way that would make it acceptable? We said, hypothetically, we would have that officer step down from the officer position, have another board member take that officer position, submit it based on the information of the new officer, and go around that issue in that particular way.
That's great.
I just want to say,
Yeah.
I think that is excellent advice. We also similarly had all the officers sign off, but again, with the backup of board minutes would be very helpful as additional support in this type of situation to show the full commitment of the board of directors regarding this matter. I think that's really very key.
So I think building upon that question, what would happen if a board member who applies is not on the board mid-year?
That it's when you make application. You can absolutely, it's like your underlying mortgage. You could have a board member sign a loan, loan documents today, and tomorrow's the annual meeting and they're not on the board. It's their authority is as of the day they enter into the agreement.
Okay. So would condops be eligible if their payroll is paid through the condominium?
That's actually a good question. And in fact, one of my clients that took the loan it is a condominium, but they have a private dining room restaurant. And, after a lot of deliberation and investigation, we came to the conclusion that they were able to apply for the restaurant component. They only applied for the payroll for the restaurant employees. We basically treated it as a separate entity, which in fact it operates as a separate entity. It's an interesting question, one that I don't think I could give an absolute definitive answer right now on this seminar, but I would suggest that there's a good argument to be made that the co-op's portion of the payroll expense, their pro rata share based on their common interest, probably can go into the formula. I'm just kind of thinking off the top of my head because it's an interesting question, but I would think that there's definitely some basis. Whether it takes you all the way to the finish line or not, I don't know, but I would argue that would be a component.
I would just add, the law seems to indicate that what basis you're going to use to make determinations is, at least on the gross receipts side, which isn't really coming into play, but they say that you have to use the accounting financial statements. Basically, we're on the accrual basis. And if there is an allocation, it's actually reflected. Many of the condominiums or the condops that we do, there is an allocation, and the co-op itself does not just set up a due to the condominium vis-a-vis a maintenance payment. They are actually recording at a gross level the payroll. So therefore, if they're recording the gross amount of payroll that they are responsible, kind of like what Adam said, on the financial statements themselves, then I absolutely believe that a cognitive argument could be made to the SBA vis-a-vis through the banking place that you're entering into this transaction. But a viable argument can be made with that support and showing that allocation. But I think the financial statement, the certified financial statement, should indicate that indeed the co-op has payroll. If it doesn't, I think you're going to be much more hard pressed. That's just, again, without doing a lot of research, that's off my gut and reading the law of how they're looking at how you report financially the items.
Very helpful. What would be the reasons a board should not accept a PP loan, and how do you think this should be conveyed to the shareholders?
My whole point was that if you cannot legitimately satisfy the requirements, factoring in all factors, and I know from the question some people are asking, well, what about capital expenditures? How do we factor that in? Not all capital expenditures are the same. If there is a imminent project that you must undertake, local law 11 or an elevator upgrade to comply with code, then I would think that weighs heavily in the idea of we need to include this. And if we don't have the financial wherewithal because our shareholders are not going to be capable of paying in the same way that they would have paid before COVID, because remember, it's COVID has to be the factor. And if, let's say, you had a vacant store for the last 5 years, and we're now in COVID, and you're now saying, well, we don't have the rental income from that store, I think you're going to be more hard pressed than if the store went vacant in the last 3 months, because the vacancy, the financial harm that you're suffering from, is not related to COVID. You had that before COVID was on anyone's lips. So, I think, again, you have to look at it as the whole. You got to look at each component that you're using to justify why you need these funds. And if you can look in the mirror and without smiling, make the argument, and it's a legitimate argument, you're on the better side than someone that can't. So when shareholders, say, well, why didn't we take the money? It's the right answer may be, well, we didn't qualify for the money. We couldn't justify it. This is a program based on need. And while, everyone would love some free money, we didn't meet the requirements, and we weren't about to put ourselves in a position where, we're making a fraudulent representation to a lending institution or the federal government.
Adam I'm on point with them. There's different ways to look at the financial statements. I mean, cash flows would take into account the capital expenditures. So if it weakens the cash amount that's on the balance sheet, that would definitely go to a way of justifying the PPP. But again, it cannot be taken flippantly. It really has to be analyzed with your professionals, because, as Adam said, you don't want to do any fraudulent type of wanting for money. As people read the publications when these things first came out, these basketball teams, these Major League Baseball, I mean, all these major league big conglomerates were taking PPP money, and they got themselves into some major hot water. Board of directors certainly don't need this. It's a non-paying job. However, everything should be analyzed with your particular accounting firm and law firm and managing agent, as I keep on saying, because that triangle can't be more important with critical decisions like this, to come up with a viable determination factor, because you do all have to report to your shareholders, and everyone hears things on the golf course and wherever course they're on. Golfing may be out right now also. So you have to have this thing very well thought out and, again, documented. Either side of the coin, which way you're going to go on this. Not one, one size shoe fits all.
Makes sense. All right, so this is a hypothetical question. A co-op has had an empty commercial space for 2 years, but it has very healthy reserves. The commercial space continues to sit empty during 2020, and because the deal fell through during the pandemic. So what do you think about the argument for a PPP in this case?
I think that I touched upon that briefly, what I just said. The idea that this was vacant for 2 years before we heard of COVID does undercut the connection to COVID. The fact that a deal was being put in place and then it fell apart, maybe that does lend some credence to the idea that COVID has impacted it. But you said they have healthy reserves, and that's going to be another factor that needs to be weighed in. I mean, how you can never be too rich, but if we look at COVID from today going forward, I think most people would suggest, and I'm saying this with fingers crossed that it comes true, that come the springtime with the vaccinations rolling out the way we hope they are, are these entities going to be able to survive on their reserves for the next several months? And also bear in mind, you're talking about 2.5 times your payroll. That's not going to necessarily make a huge dent in a lot of the economic harm that has probably been suffered from having a commercial space vacant for that period of time. So again, these are questions that need to be looked at carefully. Whether the shareholders are able to pay an assessment to cover the shortfall. Some buildings, I think safe to say everyone has been affected economically in some way. Some buildings more so than other, based on the safety net that the shareholders had to start, what type of incomes they had, what was the source, were they in more people in industries that were affected? If you have a building that was made up of a lot of waiters and service providers that found themselves unemployed or significantly underemployed, then that would weigh in differently than in a building where people are more financially secure, albeit hurting, but more financially secure. So again, every building has to, I can't emphasize it enough, every building has to do this analysis looking at all factors.
Okay. How would overtime for security personnel or other third-party companies figure into the calculations?
So the security portion, if they're not part of the W-2 per se, is difficult to add on to this formula. In fact, you're really precluded from adding on an outsourcing type of individual. However, so that would not count towards the 60% regarding forgiveness. However, as I said earlier, the new line, if you had to hire the protection because of perhaps threats of vandalism, again, all documented in your board minutes, because of rioting, fears of attacks, which is really, really very true, unfortunately, now in the city. You certainly could add it as part of one of the ladders on the ancillary side for the enhancement package on the PPP, but it will not count towards the 60%.
Neil, what about temporary replacements for staff that had to go out on because they had to quarantine? With those?
Yeah, no, that's different because those
Okay.
those people, absolutely, that's different because those people will be W-2 employees. So if Jones was out, and we don't want to get into FFCRA and other types of benefits in this format because the building could get some benefits as far as that's concerned. But absolutely, positively, once you add on the individuals to replace Jones because Jones was ill, those will the bottom line is it goes to the W-2. W-2 is our guiding light over here. Some people use PEOs also. I don't want to get into that. We're going to get very complicated on these kind of things, which are frankly legitimate. But the W-2 is the golden rule. So as long as they're on the W-2, we will use it for the 60%. If they're not, the answer is perhaps we can go into the ancillary expansion, but it won't count for the forgiveness at the 60% level. Thanks, Adam, for a good ancillary question.
That's great. Okay, so respecting the economic uncertainty question, Neil said the worst case you would have to pay back the loan. But what does that mean? The worst case of a fraudulent affirmation would be fraud.
Well, fraud is, Adam, you could.
Yeah,
Fraud is bad.
Neil said that, and I would suggest that probably what I'm going to say is not a high likelihood, but again, I'm conservative when it comes to my volunteer board members submitting, documentation in connection with loans, in connection with application to the federal government. Technically, it's fraud, and there could be criminal penalties for fraud. Now, again, I really don't believe that there's a high risk of that happening, barring other factors. But I look at it as, do you really want to go there? Who knows? The federal government, they've got unlimited resources. 2 years from now, they could start auditing these things. Do you want to run that risk? What if you're a high-profile individual? I mean, some buildings in the city have high-profile individuals on boards. The IRS doesn't go after everyone, but they do go after some people who will be a headline. So I'm not as easy with passing the test. I say, do your analysis. If you are comfortable and can, with a straight face, say that we qualify, then by all means. But I'm not prepared to tell a board member, sure, sign here, unless they're comfortable that their analysis is correct. Because as remote a possibility as it is, I can't say with 100% certainty that it doesn't turn into a disaster for them. And for what? For what?
Yeah, I just want to add, I don't want to be cavalier or again, flippant in my discussion where at worst case it'll be a loan. Again, if it's fraudulent and board people know along with the analysis that goes with it. And if you have a huge amount of cash on your balance sheet and you're really not suffering and your maintenance has stayed steady for the past 3 years and you haven't made any special assessments, and probably if your maintenance has stayed steady, it's probably much more difficult to be over the horizon and to the promised land for PPP. So it really has to be weighed, and because, as Adam says, if you have it's SBA, by the way, gets it, and I think it's a 6-year statute for $250,000 or $300,000 overall. It's certainly not worth it if there's a slight degree. If the feelings are that it's fraudulent because of the huge cash balances. But again, you really have to analyze this, because if maintenance has been going up with real estate taxes, and you have these large losses on your P&L, or experiencing large decreases in your cash balances, and you
Well,
have
then it's
higher
not
receivables that keep on spiraling up, then I particularly, and I'm not calling myself aggressive. Our accounting firm is like most accountants, we're a conservative accounting firm, but we weigh all the facts and circumstances, as I'm sure Adam does, and we come up with a fair evaluation of where we see fit. But I do believe if that evaluation is done and represented properly in the minutes, you will absolutely not get a fraudulent kind of.
If it's legit, it's legit.
Right.
If it's good, it's
Right.
legit. And if it's
Right.
and if you find out after the fact that you legitimately today perceived there to be economic uncertainty, and it wound up it wasn't, I think you're okay also. It doesn't have to be that the doomsday happens, but sitting here today, not knowing what tomorrow is, but looking at what you have and what your history has been, especially for the last 9 months, I think that's the critical component. I don't think if it meets the smell test today, even if it wound up you didn't have economic downturn, I think you'd still be okay. But it has to pass the smell test today.
Now, I will tell you also, we've had clients that have gotten PPP and actually experienced a windfall, and they put it in their minutes and they documented, they crossed their I and crossed the T. It wasn't co-ops, because even though we had a few co-ops actually that did get PPP, but these other entities had windfalls, and then they immediately paid back the money with the letter, and that's the way we guided them, because they did not want to do a fraudulent conveyance, and that was our advice to them. So again, it's at the time. You do a proper analysis. As long as you're taking this seriously with your right professionals, I really think you'd be okay with your end result.
And I go back to this again. The first wave of PPP, the economic uncertainty was more uncertain because we hadn't lived through 9 months of pandemic. Now we kind of know what the impact has been. And yes, we could get another wave, God forbid, and things go even worse than they have been. But I think you lose some of the subjectivity of that question that we had back in March and April on the first wave now, because we have real data and we know how our buildings performed and we know how our shareholders reacted, and it makes it that much more challenging and to substantiate the legitimacy of that statement.
So again, you see with this debate that not one shoe fits all. You really need to get down and dirty. Really got to get down dirty and take this seriously.
Mm-hmm. Mm-hmm.
Great advice. Okay, so about the process. Is the process completely online, or do we have to scan lots of paperwork to the banks to finalize the application process? Ajo?
So it's an online process. You will have to, and not at the first go around, you're going to give them the application. You don't have to immediately give them, at least my understanding right now is immediately give them the 941s at this first undertaking. You have to get that application in. Then the bank will ask you, at least that's how it was the last round, for these 941s. If you have everything all available at the time, of course it's better, because you don't want to get kicked out of the system. But as the question came up earlier, if you would use 2020 and they opened up their channels next week, I would absolutely not delay getting the application, and I would give it to them with the 3/4 of 20 and say the 20, the quarter ending December 31st will be forthcoming, because you don't want to give SBA, frankly, the banks, any excuse. But it is all an online process. Human beings can't possibly do the voluminous amount of these applications that are going to come in, not only from co-ops, but from every entity under the sun to get this money.
Right, and just to touch on what Neil said, when we prepared the paper applications, as I mentioned earlier, that was so the boards can see the actual application you could see what you need to fill out, the loan amount, and all the certifications. And as Neil just said, and as the practice is that we have to submit it through an online portal via an SBA approved lender. And that's the only way this can be submitted.
Okay.
You used it as a worksheet. The printouts
Exactly.
were.
Yeah.
That's
Yeah, and for us to receive signature from the board as well, so there's documentation and,
absolutely.
and covering all those bases as well.
I will say frankly, and it's not a commercial for ACAM, but they have been on the cutting edge, honestly, what we've observed with our clients on the side of this PPP, trying to be very user friendly. So it's a big compliment to them. And it's not because they're on their website. I tell it what's on my mind. So it has to be the truth.
Yeah, you can feel free to keep firing away all the good things if you want. Don't worry, you got airtime. Okay. All right. So here's another question. Can a New York City residential cooperative with relatively minor commercial revenue, garage, and one office rent, and with apartment maintenance fees, all substantially current at this time, legally certify an application for a PPP loan that, on the basis of possible COVID-19 spikes in New York City, the current economic uncertainty makes this loan request necessary?
I don't know. What was their past? I mean, what was their past P&Ls? Did they have big losses in the past? Because I didn't hear that in their description.
Doesn't state that in the question.
Elise, it sounds to me that they're not really being able to demonstrate, because yes, we may have additional spikes, but
Okay.
we've just lived through 9 months of us being New York City being ground zero, the worst outbreaks in the country. I don't know that we're going to get to that point again. I'm hopeful that we're not. I'm looking at it more optimistically that we're going to get through some cold months right now, and then we're going to, be on the other side of it. But it sounded to me from the criteria you just read off that that's one of those difficult cases to make out, that, you can't just say, I think the sky's going to fall tomorrow, therefore give me all this money. You need to have more of a realistic, approach to it. Did it fall in the last 9 months? Did you suffer in the last 9 months when we went through, a really bad time? And if you didn't, and look, if you have a major commercial restaurant in your space and it makes up a significant portion of your budget, and you have indications that restaurant is going to go dark and you're going to get the keys back, well, that would be, I think, a factor. But again, this is all so fact driven that, it's impossible to answer hypotheticals. Neil's pointed out, there's a lot of data that needs to be factored in, a lot of analysis. What's in same situation for the most part in one building compared to the next, but there's one variable that's different. It may change the whole analysis. One building may be made up of multimillionaires, and the next door building is not, and the same exact circumstances, and the one building will be able to legitimately apply and the other wouldn't.
Right. Yeah. If you have to pay back the loan, what would be the term? Is it appropriate to use the PPP as a low interest loan to mitigate the size of an assessment or maintenance increase due to losses in income due to COVID related commercial vacancies, or is that not a solution?
Oh, I mean, it's a source of money. So the board can feel free to use the funding as a short-term loan. I believe the payback is a 2-year payback. A 0.5%, you're not going to get cheaper money anywhere. So, I mean, they could certainly use it as a stopgap measure, if you will, to fund, I guess, a project if they have it. But they have to know that down the road, they're going to be knocking at the door. You will need to repay it just like any other mortgage. Now, the only problem with the loan, there could be some legalistic problems or covenant problems, because most of these co-ops have mortgages, and the mortgages usually have first rights under their covenants. So paying back this loan, one would have to look at the documents, and one may have to get permission of their mortgagee if it does indeed become a lasting kind of loan for 2-year period. So it could create
Yes.
some ripples, has to be analyzed a little bit. But again, for the short-term gap, the easy answer is they can use it, but after the 2-year period, it has to be paid back.
You raise an excellent point, and I've actually been doing some of this analysis over the last week or two with regard to the mortgages. Some of my clients, they have prohibitions on secured and unsecured debt. In those cases, this loan is unsecured, but you would need the bank's consent. In others, they don't have that restriction. So that's another thing that a building has to look at and look at carefully. I mean, in some instances where I have clients that are very interested in proceeding, we're already in discussions with their lenders that hold their underlying mortgages about getting their approval. So far, thankfully, the banks are okay with it because they understand that it's probably going to be, for the most part, forgiven. And they also understand that if they're applying for it, it's going to help them get through this difficult time and make them a better payer under their mortgage. So you definitely have to bring that analysis into the picture before you go forward, because you don't want to put yourself in default under your underlying mortgage.
Yes, I didn't want to get too complicated, but you're right. You do have to discuss it with your mortgagee. And I've
If-
also found with the
if there's
buildings we've been
permission.
handling, right,
Not-
we've
not
been
all
building, and
lenders- not
they
all lenders have
generally,
it.
right, they generally have given permission because for
Yeah.
exactly the reasons Adam has laid out.
Okay. What about the provision that loans under 2 million are deemed to meet the uncertainty requirement? Is there something that they should think about, or what about, is there a reason to consider applying for a lower number than the max 2.5 payroll?
Well, I don't think they're gonna, I think most of the co-ops, frankly, that I'm thinking about are not going to be anywhere near the $2 million. Because just think of it, to build up that $2 million number, you'd have to have a huge payroll with many employees, and that's just, I mean, at least for the co-ops, and we handle many large co-op with huge kinds of cash receipts, and they have large amounts of cash as well, that they're nowhere near raking up even with the accoutrements that I spoke about earlier, near getting near that $2 million number.
It would be
I
like
think Adam and I-
750. Wouldn't it be like $700,000 a month in payroll?
Yeah,
to get to 2 million?
it'd be an astronomical number. And Adam and I both, I mean, most of our co-ops, I believe, are going to be in that $250,000, $300,000 realm, perhaps a little bit higher. But that's the way our general analysis was going. So I don't think they're going to have to be worried about the $2 million ceiling.
Okay. Someone would like some clarification. This guidance included a safe harbor providing that any PPP borrower, together with its affiliates that receive PPP loans with an original principal amount of less than 2 million, will be deemed to have made the required certification concerning the necessity of the loan request in good faith.
That's not true. That's not true. I'm not sure where he's getting that safe harbor. The only safe harbor provision happens to be if the loan's $150,000 or less. There's not as much documentation that needs to go into the applications and the forgiveness application, because there's 2 applications. There's also the computation for forgiveness down the road. But it just makes it a little bit easier and a little bit faster, but in no way, shape, or form does it allow one to bounce their way out of the need to prove that there is indeed a need for this money, that there is an economic impact, however way we analyze and define that economic impact. It's not just free money that everyone gets and then bang, you get the 2.5 times and everyone goes home happy. That is not the case, and that is definitely a misnomer. It's not correct.
Okay. Can you please clarify the definition of the term any owner of the applicant in questions 1, 2, 3, and 6 of the application?
In the owner of the applicant in question 1? Yeah, so as Adam pointed out, for example, if a board member who's part of signing this application has a problem as far as has been suspended, debarred, proposed for I'm reading right from the application. If he suffered those types of things, that's ineligible. And as Adam pointed out, if any of those criteria are met by a board member, he came up with a I think, very potent suggestion that makes a lot of sense. That board member should probably leave the board. Unfortunately, if the board is indeed wants to pursue the PPP, because when you hit these questions and you check it no, I mean, the box says right away if questions 1, 2, 5, or 6 are answered, in other words, are answered yes, the loan will not be approved. It's prima facie right on the application. So the best advice was Adam's advice that board member would have to leave the board.
I think though, specific to that application, the SBA application, any owner is considered of a corporation, any entity or person that owns 20% or more of the cooperative.
Right.
So that's a sponsor, probably. The only
No,
people
but I think that's under the SBA regs. I think that is correct. So the individual shareholder, unless they own a significant portion of the building, like a sponsor, would probably, that's why sponsors do have to submit the materials. And I think you're right, David.
Okay. Does a co-op's mortgage company or bank need to know and give consent before applying for an SBA loan?
If it's, as I said, if the covenants within the mortgage prohibit any financing, secured or unsecured, then you would need to get their consent. Some of the banks I've seen have that language. Others, they only prohibit secured financing, where a mortgage is taken against the property. So you have to, again, look at your loan documents and figure out what they say specifically.
Okay, this question I believe is for Ajo. How do you determine if your building has a large reserve? Is there a formula that we use to determine that?
I don't think that there's an exact formula for that. It really depends. There's a rule of thumb in terms of how many months of maintenance or how many months of expenses you should have. And Neil, maybe you can confirm, I think 4 to 6 months of that would be appropriate.
Yeah, we generally feel that we go 3 to 4 months generally of cash on hand makes a building more comfortable, so to speak, in the reserve. But reserves, depends on what you have encumbered. So, for example, if you have a large, because you've just done special assessments, which give people tax basis, but if you've done special assessments, that you're going to undertake some huge undertakings, like a new heating, ventilation, and air conditioning system, which, we, ACAM, many of our clients do that, then the reserve that you have on hand isn't all that much. So it's very difficult to have a real set number. It's a fact and circumstance, again, situation, depending on what's underlying that perhaps large reserve, because the large reserve may disappear in a year because you spent all the money on those projects.
I think, though, you have to look at the projects. If they're legally mandated projects, you'd be able to, I think, better justify that those reserves are spoken for, and therefore come off of your analysis of whether you're going to need it for operations. If it's that you're going to do more of a cosmetic project, something that's a glamour project, you probably, you could easily see someone say, well, don't do the luxury item, use it to cover your economic shortfall. You don't have need. So
I think you also need to look at the building's capital plan, typically provided by the management company, and we do that for our clients. Look at the capital plan, see what's coming up 3 to 5 years from now, mechanical systems, structural systems, and that'll also inform how much reserves you should have as well.
100% correct. I mean, many of these clubs, and all of them take departure from that under generally accepted accounting principles, but under that law, they're required to frankly have 5-year plans, and many do have these informal plans along with the managing agent, which are great, and that definitely goes a long way on the establishment of this PPP. So that's a great point, that's a great point.
So we have many questions, and this has been so informative, and I really appreciate you all for your time and our participants' time. Just to do a quick follow-up, are there any next steps, Audra, that you can just quickly, or you or David can touch upon for our clients real fast? And then, of course, everyone's email is listed here before. Again, you can contact us at marketing@acam.com. We're going to get right back to you with these questions, as we know this is an emerging issue. But are there some things that we can do a brief takeaway before we say goodbye?
Sure.
Go
ahead, David, please.
Good. I just going to say one of the things that we kind of touched upon but didn't specifically mention is the boards have to make sure they abide by the bylaws. So your building may want this, but you have to, if you have to have shareholder approval, as Neil I think touched upon in one of his questions, was you also might have mortgage covenants. So before you get into getting the documents together, you want to make sure you have the authorization as a board member to proceed with this, because it may turn out to be a loan if you don't qualify for forgiveness. And then secondary is make sure that if there's any covenants out there, that you review them with your attorney so that you're allowed to take these funds.
And I would just add that at this point, in terms of next steps for us, we're awaiting confirmation from our boards on whether or not you would like to apply. From that point, we'll continue to, or we'll have the documentation in order to input it into the portal when they open up. I think that, we also have a lot of questions coming in. Like Elise said, that there's certainly a lot of questions here. We have a central team within ACAM that are answering a lot of the questions for our board. So please keep them coming. We want to make sure that you're comfortable with it, with everything, and we'll take the next steps once you confirm. We've asked for a designated board member to be in contact with, and we'll be looking for information on that from the boards. And please expect another communication from us within the next day or so regarding current updates as we get them, and then just a reiteration of the next steps for the boards as well.
Great, thank you so much. And I just want to thank everyone for attending this evening. I want to thank David Palmer, Neil Sonenberg, Audra Kurian, Adam Finkelstein for joining us tonight. I think you offered really wonderful advice as we take a look at the next steps. And we plan on making this most likely a series as it begins to evolve. So thank you once again. And if you have any questions, feel free to reach out to any of us. We're happy to get right back to you. Have a great night. Stay well. Thank you so much. Bye, everyone.
Thank you, everybody.
Take care.
Well,
Bye.